Hello, and thank you for joining us today. My name is Brian Trunzo. I'm the head of sales for Project and Informa Trade Show. I'm excited to welcome you all to today's webinar presentation, Fashion Law Amidst the COVID-19 Pandemic. I am joined today by our speaker, Douglas Hand. But before I officially turn it over to him, there are some housekeeping items that I need to address. First, please note that you will be placed on mute for the duration of the presentation. All questions will be addressed via the Q&A portion at the end of the presentation. We will do our best to get to as many questions as possible in our allotted time. Second, if you experience any systems issues, please click on the help option on your registration reminder email. And finally, this presentation in its entirety will be emailed to you in the next few days, and it will also be available on fashionframeworks.com. All right, so with the housekeeping out of the way, let's dig into today's topic, fashion law amidst the COVID-19 pandemic. As you all are very keenly aware, the fashion industry has been disproportionately hit by the economic stress caused by the stay-at-home requirements and shutdowns. Resulting from this, significant legal issues are arising for many fashion companies, issues that range from bankruptcies to employment law to issues around real estate and even intellectual property law. Doug, today's speaker, specializes in fashion law. Doug is a professor of fashion law at NYU and Cardozo Law Schools, as well as a founding partner of the law firm Hand Baldachin and Associates, LLP. His client list includes notable names such as Stella McCartney, Everlane, Todd Snyder, and Zadig and Voltaire. Doug is a member of the CFDA Fashion Awards Guild. He is on the board of directors at the FIT Foundation, and he is a published author and host of the podcast, The Laws of Style. Last, but certainly not least, Doug has been featured in major publications such as the New York Times, the Wall Street Journal, Vanity Fair, the American Bar Association Journal, Women's Wear Daily, and Business of Fashion. Quite a mouthful there, Doug. So without further ado, I will leave it over to you. Doug, the screen is yours.
Thank you, Brian. And thanks to the whole team over there for putting this together at a difficult time. And all the listeners, thanks for joining during what I know is a phenomenally strenuous time for us all, both business-wise and personally. So I appreciate the time and attention. I am indeed a fashion lawyer, and my background to I guess not gild the lily on those bona fides, but I think it is important to know what my practice is as opposed to my teaching positions at law schools. I've been practicing for over 20 years, and I started as a corporate and mergers and acquisitions lawyer at a firm, Sherman and Sterling, where I practiced in New York and in Paris, but then left to form my firm, HBA, which focuses on the fashion lifestyle industry fairly exclusively. And that does give us a very interesting vantage point from which to see the developments that are happening during the pandemic, and hopefully some of the solutions or best practices that brands can implement to deal with this difficult time. So next slide, Brian. Thank you for being my slide boy. Great. Bad laws are the worst sort of tyranny. Sure. I mean, law, not to get too pedantic about it, but we should sort of start from first principles. It's necessary to order society. It's necessary to maintain fluid economic activity and so on. But the laws are really, by their very nature, restrictions on our activity and on certain business activity. Fashion and the law have had a fairly fraught relationship in this regard, mainly in terms of design protection, which we'll touch on as it's not particularly COVID related, but in other areas as well. So without taking up, the entirety of this broadcast, because I do teach the course over the time period of an entire semester, let's just level set with a snapshot of how the law interacts with the fashion industry, and a little bit on the ecosystem of the law as it applies. So next slide, Brian, and I guess a couple of other pedantic notes to make. But for those who may not be aware, I mean, you only would learn it in law school. All laws relate not just to the country, federal law in which we're situated, but in most cases, state by state. And so for purposes of brands that are direct to consumer or have an online presence, and which brand today does not, really all 50 states are typically implicated in certain legal actions, because online you're touching all 50 states, if not the entire globe. Beyond the bifurcation between federal and state, there's also another bifurcation that relates to laws which are passed by our legislators, which are rules and regulations, which is distinct from what's known as common law, which is essentially when fact patterns on disputes are put in front of a court of law and the court makes a ruling. That ruling itself becomes law that can be relied upon. And so the law advances in that way. And often it is the courts that are making the interpretations of what the legislature has passed in rules and regulations. So you have a very tightly prepared chart with a lot of different legal areas that perhaps in a law school setting or in a case book are areas of law, but they are the areas that really touch. I don't want to let anybody in IP. It's on the next slide, which we'll get to after we go through this. But obviously, starting somewhat from the top, corporate finance and M&A, which is mergers and acquisitions. Fashion companies are through debt or equity all the time. They're also bought and sold all the time. Some of the distinct issues that are present for fashion brands can relate to the fact that many fashion brands are eponymous brands. The founder of the brand chose to name the company either after their family or after themselves. But one can imagine that when you are taking on an equity partner who may be taking a significant stake, 30%, 25%, or on the further reaches, actually selling the company, if that company bears your name, that decision is a little bit more complicated. It's more complicated, obviously, because there are hallmarks of just your personal legacy associated with that sale. But they're complicated for the investor or buyer as well. All we need do is look at a situation like John Galliano, and obviously gifted designer, but his rant, anti-Semitic rant outside of a cafe in Paris, obviously did some significant damage to that brand. Putting aside, his gifts as a designer. Other examples, maybe not so recent. I recall that when Donna Karan sold her company, which it's been sold a couple of times now. So it was sold to LVMH, but then it was sold to a company, G3. G3, who owns it now, had to absorb some significant losses when, amidst the Harvey Weinstein situation, I think Donna made some supportive comments about Harvey. And again, with no comment on those comments, the financial impact on the brand was actually pretty severe. There were several large wholesale accounts which dropped DKNY really through not G3's actions, but through through the founder's actions. So, on the investing side, it's also fraught with some concern, and that makes M&A in the fashion space, both a personal and a business project at times. Moving on to commercial sales, those are your contracts with mainly your wholesale accounts, right? Your relationship with your wholesale accounts is very important. But those commercial sales contracts can also govern your sales to customers. And in that sense, they usually live on your website in the terms and conditions of your website. Commercial sale agreements in a more traditional wholesale setting involve bad words like chargebacks. Then on somewhat the flip side, for the brand in trying to put some obligations on wholesale accounts, compliance terms and codes of conduct. This has become more important today as consumers are taking more and more of an interest over perhaps environmental claims or labor-friendly claims that brands may be making with respect to their methods, not only production, but also sales. And the brands are well advised to have codes of conduct, which both ends of their supply chain sign up to, so that when they're making representations about how they interact with the rest of the world, they are clear that other parties they do business with are adhering to that as well. Moving on to other areas like sourcing and customs regulation. Here, as it won't surprise anybody, you have a lot of international contracts. And so while I'm a U.S. lawyer, obviously import-export involves the rest of the planet. And a lot of products are made outside of the U.S. And so classifications of goods is an important concept in this area, as well as labeling, obviously. Labeling is a highly regulated area, one that you guys all deal with. Has real implications because relabeling can cost quite a bit. Also, this area would cover duties, VAT, and other elements. Employment law is certainly something every business that employs people deals with, obviously. But in fashion, it's fairly distinct insofar as there kind of are three classes of employees for a fashion brand that has its own brick and mortar retail. Two classes if there isn't brick and mortar retail. The design group, which often, as many of you know, is comprised of a core design team, but also many contractors. The design work is rife with independent contractors because season to season, you may be using different specialization techniques that you don't need 365 days a year. And so you use contractors. The important thing, however, for every business to know when using contractors that are creating potentially intellectual property for the company is that there needs to be a written work for hire agreement with that contractor, or else the intellectual property that they create, believe it or not, actually remains with them and is not conveyed to the company. That is not the case for an employee. One of the benefits of having the employee-employer relationship is all work product from an employee automatically goes to the employer. But just important to note with respect to design employees. And then, as I imagine many on the call are, the executive ranks of brands are much like the executive ranks of a lot of companies. But as we know in the fashion industry, non-competes and non-solicitation provisions are fairly heavily negotiated in those contracts. And then last but not least, retail employees. Retail employees who, in many cases, are not with the company physically. They are at the store, and they work in shifts, and they work in different ways than most employees do, insofar as their payment may have a component of commission associated with it, which is regulated differently in each state. And overtime rules and regulations for those employees is different from state to state. So brands that have retail footprints have a lot of little small islands of potential liabilities, not only in New York, California, Florida, but potentially all over the U.S. And so that can be a very big area where the fashion lawyer works with brands. Relatedly, somewhat, moving on to what most lawyers would call real estate law, but in the fashion world, it's really leasing. Most brands do not own their offices, their showrooms, or their retail stores. And with respect to the lease that governs those environments, there is a lot of potential liability. There is a lot of economic liability as brands that do have retail store portfolios during the pandemic are obviously aware of, while people cannot shop in most of them, but landlords certainly take the position that they are still due rent. We will talk about that in further detail a couple of slides into the future. Another area that we certainly cover is licensing.
It appears that we may have lost Doug. He was having some issues with his Wi-Fi. So we're going to give him a moment to rejoin us. So I just request that everyone in the audience patiently wait for his return. I know he was just about to crack into the good stuff, the pandemic-related, COVID-related legal issues that he wanted to talk about. So again, it appears that Doug has had some Wi-Fi issues, and I hope everyone can show some patience in waiting for his return. So I will be disabling my camera, but the slide will remain, and Doug will be with us shortly. Also, as we await for Doug to return, we've already had some really great questions come in from the audience. I would just request if anyone has any questions for Doug, either related to the general legal topics that he's already covered or anything more specifically related to the pandemic or COVID, please send us your questions via the Q&A in the chat here, and we'll do our best to get to those questions when Doug returns at the end of his presentation. So again, they can be anything ranging from very general legal questions that you believe Doug has the expertise to answer, of course, or anything specifically related to either your business or any pandemic-related fashion-related inquiries that you might have. So thank you for your patience again. To everyone who is patiently waiting on the line, we've been assured that Doug is trying to log back into the On24 platform. So again, just some housekeeping and reminders to everyone. Any questions that you may have whether general or specific in nature related to this pandemic, legal issues around the fashion industry, around fashion law, please submit them through the Q&A that's on your control panel on this platform. Again, Doug is trying to log back in, so just patiently wait. We request of you, please, and he'll be joining us shortly, I hope. Thank you. A fun fact about Doug, and a way to keep you engaged while he's trying to get back onto the Wi-Fi, is that his book, The Laws of Style, is available. And with Father's Day just around the corner next month, June 21st, it would make a really great gift for any style-conscious father out there. So The Laws of Style by Doug Hand, just plugging him while he's trying to get back on, keeping you guys engaged. Father's Day, very important. Make sure, respect to all the dads out there, buy them a great gift, whether it's The Laws of Style or something else. Yeah, don't forget about the dads out there. Also, as a reminder, this presentation will be made available after the day's end on fashionframeworks.com. So in the event that you need to leave or do not have the patience to await for Doug's return, of course, this presentation is being recorded and will be made available on fashionframeworks.com.
Am I back on, Brian?
It looks like you are back on. I was going to give you another plug to keep our audience entertained and talk about some of the guests that you've had on your podcast, which range from Alec Baldwin to Nick Wooster. So very, very, very diverse group of panelists that you've had on your podcast. So without further ado, I will exit and give the screen back to you. Thanks to everyone for their patience. Thank you.
Thank you, Brian, and apologies, everybody. So in terms of IP, there is the holy trinity, right? There is trademark, there is copyright, there is patent. And often in the fashion industry, designers and business people get these areas somewhat confused or use them in overlapping ways. Copyright which perhaps affords the least amount of protection, but is the easiest to obtain, relates to any newly created work. So think a photographer, when they take the picture, they have the copyright in that image. A musician, when they write the song, they have the copyright in that song. So does a designer, when they design an item of apparel, have a copyright in that design? The answer is usually no, because most designs are predicated on designs that have existed before. There is a fairly high bar on creativity when it comes to useful items like apparel. And so where copyright typically touches on the fashion industry in terms of protection is prints. So obviously, if you're making a bespoke print that you have designed yourself, that is protectable in the same way any work of art would be. Often jewelry, again, akin to a work of art, is protectable. Obviously, most brands use images, so the imagery that you do take and your media assets are protectable by copyright law. Copyright lasts from when it is created, the life of that author, and then usually for another 70 years. So it lasts a good long time, and it's relatively cheap to obtain. Trademark is by far the most prevalent form of IP protection that fashion brands make use of. That is your brand, that is your logo. That can also be your color. So think, Tiffany Robin Egg Blue is a protected trademark. The Louboutin Red Soul, as slightly mitigated by a court decision, is a protectable trademark. Also, certain design elements are also protectable as trademark or trade dress. So here, think the Adidas stripes or other, it does often come up with sneakers. Other elements that you would look at and say, oh, well, that's design. It also, because it communicates and that trademark law, it actually, here in the US, originates from a consumer protection ethos. It is not there for the brand owner to necessarily consider an asset and monetize, although they do. Its roots are really in protecting consumers as to the source of goods and that they are getting authentic goods. So if I look at a Maison Kitsune sweater and see the label in there, I know I'm getting authentic Maison Kitsune goods, and I am not in any way hoodwinked. But that also allows the company to protect those rights. Trademarks can be diluted if not protected, and what that means is it's pretty simple. I mean, if Rag & Bone allowed a company, Rag & Stone, to exist, selling similar ready-to-wear denim apparel items, there would be some confusion in the marketplace and some dilution over the value of the Rag & Bone trademark, assuming that Rag & Stone was a cheaper, less well-constructed knockoff. And so those things need to be both monitored, and then if and when you find semi-pirates, like that example, the brand is best advised to go after those people and sue them both for dilution and trademark appropriation claims. The interesting thing about trademark, before I move off of it, is that it does somewhat favor the old over the new. I mean, when you think about the fact that the trademark only really springs to life when consumers recognize it as the brand, that obviously favors a brand that's been around for decades over one that is just starting. And so that is a constant complaint of younger brands as they try to expand into different product categories. They're always up against those that have been there before with longer standing, just temporarily, just over time, longer standing rights potentially that close them out of certain markets, which is somewhat of a flaw in the U.S. industry or in the U.S. jurisdiction. Speaking of other jurisdictions, we always advise clients to register both in the United States and in China concurrently. China is what's known as a first to file jurisdiction for trademark protection. What that means is like what it means for URLs here in the US. Someone with no intention of actually using the brand name can still file for it and get a registration in China, and then simply wait for the brand owner in some other jurisdiction, in this example, the US, to need it in China, which China's a massive market. It's markets within markets. So most brands will need it. And then they just have to pay these trolls to obtain their rights. Much better to simply register right out of the gate. The US, to distinguish in terms of how registrations are obtained, you have to be using in commerce the trademark before it will register. You can file on an intent to use it in commerce, but it will not register unless and until you've proven to the US Patent and Trademark Office that you're actually using it in commerce. That leaves us with patent.
Hello, everyone. Again, my apologies again. We seem to have some more technical difficulties on the connection side with the Wi-Fi at Doug's home. So we ask again that you patiently wait for his return. Hopefully we can get him at the very least dialed in. We might not have video, but audio would be enough. So again, experiencing some more issues, and we apologize. Before Doug returns, as we're sorting through his technical difficulty, another fun fact about him, back around 2011, Doug had a column on the now defunct Park and Bond, which was previously owned by Gilt, of course, called Style Counsel. And Style Counsel was a very cheeky take on the word counsel, whereby he offered advice on how to dress more professionally in the workplace, depending on what your workplace was. And at that time, I myself was a corporate attorney who actually hated his life for many different reasons. If anyone wants to talk about that at any point, you could email me at brian.trunzo@informa.com. But in any event, it caused me to reach out to Doug. And Doug actually was one of my first mentors and challenged me to figure out how I could become involved in this industry that is now, my home. So in any event, just a fun fact about Doug, a fun fact about myself. Doug appears to be joining us right now. So my hope is that the video works. If the video doesn't work, at the very least, we'll have some audio. So again, thank you for your patience, and hopefully Doug will be with us shortly.
Hello?
Yes,
Hello?
Doug, we have you back, at least on audio.
Yeah.
So thankfully, Doug has returned. Doug, because we've lost a fairly significant portion of time, I think it might be best if we move forward into some of the more COVID-related topics that you had planned on speaking of today. And then we also have some really wonderful questions as well. So great to have you back.
Okay, and apologies, everyone. So obviously, as we started, the fashion industry's been disproportionately hit by the economic stress caused by stay-at-home requirements and shutdowns. I mean, there's no shopping at stores, there's no production. Loss of a season sends ripples out, impacting brands, retailers, factories, raw material suppliers. The government response has been meek. Let's face it, 8 weeks of payroll and rent protection are simply not enough to deal with the losses involved. And many brands, retailers, and factories simply won't survive. John Barbados filed for bankruptcy protection last week. True Religion filed a few months ago. And on the retail side, we are seeing more and more filings, and they're likely to accelerate. Obviously, Barney's hit the industry hard, and sales weren't great before COVID, but COVID just absolutely nailed Neiman Marcus at the worst possible time, and they have filed. J. Crew, which I realize is more a brand than a retailer, but they've been a retail partner to many, filed a couple of weeks ago, and I wouldn't be surprised if JCPenney and Macy's file before this is over. Most of these filings are what's known as a Chapter 11 filing, which is a reorganization, which is good, better for brands than what's known as a Chapter 7, which is just an outright dissolution. That's a fire sale. That's wheeling everything out to the front lawn and just selling it for scrap. A Chapter 11 is an attempt to reorganize the business and have it continue as a going concern under the theory that it's worth more as a going concern than it is for scrap. So what happens when a retailer files? Legally speaking, and I'm not kidding here, you enter into a bit of a twilight zone. The debtor, so in this case, let's just use Neiman Marcus as the example, they file to get what's known as a stay from creditors. That means creditors can't seize their assets, can't prevent them from doing business, but all of the business decisions need to be run through, at that point, a bankruptcy court and a creditor committee. But this gives the debtor the ability to accept and reject contracts, meaning accept new contracts during the filing, reject old ones that they don't want. Now, while this mainly hits retail leases, and obviously retail lease portfolios and the large monthly rental nuts that people have had to pay is one reason to file, and you can reject those leases, and those landlords are left with a claim, nothing more than a claim, and the lease goes away. It also allows retailers to reject purchase orders. And, the real question for most brands is, what do I do when I've got accounts receivable that was due before the debtor filed, and what are my rights to get payment on that accounts receivable after they have filed? The back of the envelope math is usually that pre-petition, so before the filing, AR usually pays out at about 10, 20 cents on the dollar, which is a pretty sobering number, meaning 10 to 20% of that AR amount gets paid out. Obviously, it depends on the actual amount of debt that the company has, but in a reorganization, that usually is about what gets approved. And so while it is important to file a claim for outstanding AR, and without filing that claim as a brand, you will have no standing to get anything, and 10 to 20 cents is better than zero. It is a difficult situation for many brands that they are facing. Now, what if you believe a brand is going into bankruptcy and you want to get paid even though maybe payment isn't due right now, or you know that other parties aren't getting paid? By all means, hit the phones and bang people's heads to the extent you can. But what's important to recognize is that within the bankruptcy, there's a 90-day period prior to filing where creditors, once the bankruptcy is filed, can bring preference actions. What a preference action is when the creditor believes that someone pre-petition was paid out of order, that it was a preferential payment, and that can be clawed back, and often is. So if you get paid within 90 days of the bankruptcy filing, just earmark those dollars, so to speak. I don't mean don't spend them, but I guess just be aware that you may get a preference claim made against those dollars, and they may be clawed back. And so I'm really saying budget for that potentially to happen. How can you? Well, there are a couple of other things that are at least worth mentioning. There are waterfalls in terms of who gets paid out of a bankruptcy. The first rung of that waterfall is the secured creditors. And the secured creditors, it won't surprise anybody, are essentially the banks. They have loaned the retailer money on the basis of getting a security interest in all of the retailer's assets. So that's not just the fixtures on the floor, the buildings if they own any. That is the inventory that they hold. And what can really just smack a brand is that there is your inventory that you haven't been paid for, sitting in Barney's, sitting in Neiman's, and it's not yours any longer. The money that is generated from it is not yours any longer. That money will go to pay likely the secured creditors. I mean, theoretically, a portion of that money is yours, because if it finally, pays off all the secured creditors, and then another class of creditors, which are administrative claimants, and then finally get to you in the unsecured creditor class, which is where you reside on those pre-petition accounts receivable claims. But again, the usual payout is pennies on the dollar. That being said, if inventory that has been shipped within 45 days is sitting at a retailer, and at the time that you shipped it, the retailer was insolvent, which if they filed within 45 days is typically the case, you do have 20 days to make a filing to get that inventory back. And in many cases, you can get that inventory back. That's important to do. I mean, obviously, holding the inventory is better than holding nothing, better than holding the AR, which may not get paid out. And so those are some of the things that that brands should be thinking about as the Neiman's situation evolves and as other retailers potentially file for bankruptcy. One of the things I think brands should be thinking about proactively with respect to retailers that have not filed is either changing your payment terms and getting paid up front or COD, or if that's not available, and it is often not with retailers, selling on consignment. And when your inventory goes into the physical location of the retailer, filing and perfecting a security interest in your own inventory. It's fairly simple to do. It's a UCC filing. And then there's also a notification requirement that has to be filed and sent to any secured creditor. And those, again, are usually the banks. But that puts the world on notice that the inventory in that location is still your property. And if the debtor files for bankruptcy, you can go in and you can get it. And that's a much better position to be in than either holding AR or, holding some promise that that inventory may get shipped back to you, because in most cases it will not. Moving on to employment matters during the pandemic, obviously a lot of brands have had to go through terminations, terminating employees that they can't pay, and furloughing employees that they can't pay. More so on the retail side, but brands are exposed not just at retail, but their entire operations. It's been an overhead cutting measure, and it's important. But keeping those employees on payroll is possible, at least for the 8-week period that might be covered by the Payroll Protection Act, if you have filed. I know that process has been very, very difficult for a lot of brands to go through. It's been made more difficult than it should be, and a lot of banks were very slow to open their portals for applications to go through. But just recognize that at least 8 weeks of coverage can be there for salaries of up to $100,000. It's important to note. So that does cover most retail employees. It may not cover high-level design employees, high-level executive employees, and so that's worth consideration that you're not going to be covered on at least the loan forgiveness on amounts of payroll above $100,000. But 8 weeks is only 8 weeks, obviously, and so it has caused a lot of brands to have to go through the process of furloughing and terminating. The key in those situations, and this applies, both for termination and furlough, is not to engage in any discriminatory or retaliatory practices when deciding who you're furloughing, who you're terminating. So as you would in a normal circumstance, evaluating the risk profile of any termination or furlough that isn't being done across the board. If you've got one Native American woman in a store full of white guys, you may want to just evaluate that that's a high-risk situation to furlough or terminate that particular individual. Moving on to leasehold issues, which obviously leases are another big component of overhead. And in most cases, right now you're not using the space. And so you may be asking yourself, why am I paying rent? What should I do? The answer is different for stores than it is for offices. For retail stores where the premises, may not be open to retail traffic, some brands are actually putting forth the argument that the lease can't be performed and it's therefore terminated. In some cases, that argument is based on the lease itself. There may be what's known as a force majeure clause in the lease, which permits the termination of that lease or a stoppage of paying rent when those force majeure events are occurring. Those often cover pandemics. They don't always. So reviewing the force majeure clause is important. However, many leases don't have a force majeure clause. So absent that, some tenants are relying on a somewhat arcane and rarely tested legal theory called frustration of contract. This is when, because of no fault on either side, either party to the contract, there is an event that has happened that really just negates the purpose of the contract. And when you think about it, at least with respect to a retail store, that's a pretty good argument. You know, if the mall in which your store sits is closed and not open for business, it's pretty good grounds to say to Simon or Resnick or, related, I'm not paying my rent because I can't use the space. And the contract is therefore frustrated and I can terminate it. So these brands are using that as an argument to say not only I'm not paying rent, but the entire lease term is done. And that is sending some shockwaves through the landlord community, obviously, because post-pandemic, when we get there, many people expect that rents are going to be significantly less. And so if you have a tenant in a long-term lease that they are taking the position they can rip up, that is very, very detrimental to your business prospects as a landlord. In any event, when evaluating your lease, whether it's your office space, showroom, or a store, you got to take into account, is there a personal guarantee? Are you a small enough company that they extracted a personal guarantee from either the founders or major equity holders? What are the terms of that personal guarantee? Is it a good guy such that if you clear the space out, it goes away? In which case, clear the space out before you stop paying rent so that you don't default on the lease terms before the good guy guarantee goes away. How much is the landlord holding on deposit, and how much is left on the term of the rent? If they're holding 4 months of rent and you've only got 6 more months to go, you can let it go, and most landlords aren't going to come after you for a mere 2 months of rent. And do you want to stay? Is it a space that you actually like and want to stay? And if that is the case, then approaching your landlord and, whether it's hat in hand or with legal theories, I always like to have some legal theories to gain some leverage in the situation, attempt to renegotiate and extend. And most landlords would be very, very happy to hear that, as they don't want empty space. Empty space doesn't do anything for them. Also on return to work issues. So as you may all know, in Texas, Colorado, Georgia, stay at home is over and people are returning to work and to stores. I read a draft of an article that one of our associates is going to be posting later today on our website, which is hballp.com. And it's on, some best practices as well as regulation on return to work to avoid legal liability from not only your employees, but also customers, right? So the distancing, having limited number of people in the store at any time, having some form of remote pay, whether that's Apple Pay or other, so that people don't need to touch, perhaps having customers bag their own items, or other processes by which the store environment can be rendered safer are advisable to follow, because the wave of post-pandemic claims that may come from people who were affected or had loved ones who died during the pandemic is what a lot of plaintiffs' lawyers are kind of licking their chops at, believe it or not. Somewhat lastly, on IP protections, and this is the last slide, those have lapsed a bit during the pandemic. I'm not sure if this is because the courts are kind of slower operating. They're all dealing with social distancing as well, and trying to conduct sessions via Zoom and otherwise. So the court system has come somewhat to a grinding halt. or that brands are really dropping enforcement of IP rights as a cost that they can't afford right now. But obviously, damage to IP can have a lasting impact on the brand. And we're working with a lot of our clients to make sure that IP protection is maintained, and working with them on billing that appropriately, and allowing them to pay for that if and when they can. Contractual rights. This is important because during this difficult time, there's a lot of uncertainty, and therefore there can seem to be a lot of lawlessness. I say that because contracts are obviously important to codify an understanding of a business deal, and the process for obtaining recourse if that business deal is breached. But leverage is also important. Just out there in business, leverage is important. And I'm sure some of you are dealing with canceled orders based on terms that don't permit cancellation. POs are a contract, but they're not always being honored. And what are you going to do? Are you going to sue a wholesale account? Are you going to burn that bridge? I mean, maybe you are if the amount is enough. But, it's a very, very sort of Faustian pact that you make when burning that bridge. Also, the process for suing, particularly now, is not only time consuming, but it's expensive. Can the brand afford it? And if you prevail, are you going to be able to actually collect? Sometimes winning against a soon-to-be bankrupt party is just that. It's, again, back to our discussion on bankruptcy, an unsecured claim that gets paid out with other unsecured claims. So we always advocate with respect to POs and other important contracts regarding payment to include what's known as a legal fees reimbursement provision in the event of non-payment, and you have to actually engage lawyers to get your bills paid. It can be a real leverage provider because it's kind of a double whammy when you think about the retailer knows they have to pay what they didn't pay, but in addition, all that your lawyers run up in chasing that money, they're also going to need to pay. And that brings them to the table closer because most non-payment situations wind up settled. Non-payment situations are probably the most layup of litigation claims. There's really no dispute. The contract says you pay, you didn't pay. So they don't go to court, they settle, but you want as much leverage as possible to get the largest amount in that settlement as you can. It seems a little lawless right now. These are scary times. Many brands are looking for guidance as the government navigates, its response to COVID, return to work, and relief for COVID. The guidance from the government has obviously in many instances been far from clear. So as an industry now, where do we find ourselves? It's a somewhat dark place for sure, but there are always great opportunities as we come together. And these are certainly adverse conditions, but I wish you all well and remain hopeful that through collective action as an industry, we can enact some changes for the better for the long-term prospects of us all. So with apologies on all the technical difficulties, that concludes my remarks. And I think, Brian, we can open it up to Q&A.
Thank you so much, Doug. A really great silver lining here is that we had plenty of time to receive some really interesting questions. And we're seeing a wide smattering of questions. I think it's representative of just how multidisciplinary fashion law actually is. So I'll do my best to lump some together as I make my way through the document of the questions that came through. You mentioned in terms of liability, your firm will be publishing some sort of a memo on your site. So I thought that it would be interesting to maybe delve a little bit deeper there because we did receive quite a few questions about what kinds of liability a store owner or a brand, a retailer can expect to sort of try to mitigate against in their leaseholds, in their real property. So if you go a little bit deeper into employer liability in retail.
Yeah, well, that's a great question. And for those of you that have had stores, you probably have been hit with what we call sort of an ADA drive-by claim. Most stores have adequate access for wheelchairs. That fact notwithstanding, there are plaintiffs' law firms that essentially look for any aberration in terms of egress and will fire off a letter, which is a form letter, asking for a settlement payment. You probably have also been hit with the ADA claim that relates to those that are sight impaired, not having appropriate access to your e-com site, and asking a bunch of questions about your IT, and ultimately resulting in those plaintiffs' firms asking for a settlement amount, and that devolving into a back and forth over what the appropriate amount to settle is, to avoid the hassle of an ADA litigation. It's hard for me to, look, a lot of these regulations, and we haven't yet seen the COVID regulations come out. So this is really just almost prognosticating from, what exists out there and what brands have been up against. Plaintiffs' lawyers, and I sit here as a lawyer, but not as a plaintiff's lawyer, what they do is look for regulations that have any indicia of perhaps not being performed wholly, and extracting a settlement from defendants. And they come in waves because there is efficiency for those plaintiffs' law firms to, like I said, come up with the form letter, which lays out the perceived infraction, and develop sort of what they think fair is perhaps the wrong word, but an appropriate amount of settlement is going to be for the littlest amount of work. Recognize that these lawyers would have to go the full length to sue the brand and be victorious, and that's a lot of work for them. They take these cases on contingency, and they get a portion of the damage award. So their incentive is to get settlements quickly, and spend the least amount of time in doing so. So what do we think will come out of the COVID situation? Well, it's going to radically transform the way in which stores have to operate, right? I mean, unless there is some silver bullet cure, social distancing is going to be with us for a while. And that is a very, very difficult thing to really control in a store environment. And so what I see coming down the pipe is, unless you can somehow prove that everybody was 6 feet apart, if somebody comes out of your store location and was sick and incurred some damage, that is an opportunity for a plaintiff's lawyer to write that letter and extract that settlement. Now, if you just got sick and you didn't die, I mean, what are the damages? Maybe not so much, but God forbid, actually somebody died, right? And what are the damages? They could be significant. Often your insurance policy will cover these claims. That's important to look at and know. But as you reevaluate, what your insurance is, I can assure you that these cases will come, and that you want to make sure that you are covered in the context of potential COVID exposure. So that also sort of, in the context of those claims, following best practices is important. What are best practices right now in terms of store environments? We don't really know yet, right? I would think having some sort of a barrier between, where the register is, a see-through barrier, but, kind of like a gas station in a sketchy neighborhood, but doesn't need to be as thick. Having everyone appropriately masked, obviously. And like I said, the appropriate social distancing. That is to insulate you both from customer claims as well as employee claims, because your employees could also get sick and similarly bring a claim. So you've got two camps of potential litigants, and it starts to make you wonder in this environment, is it worth opening a store with that potential liability? I'm hopeful that the way courts will rule will be to ensure that, yes, it is still worth it to open a store, but that's going to be on a case-by-case basis. And, these are the types of steps that I think all brands should be following. And as they develop, we're committed to trying to get that information out there so that people know what best practices are in this regard.
Thank you, Doug. There are a few questions coming in related to bankruptcy, and I think that's unsurprising as, it's a time of restructuring, unfortunately, and we're seeing a lot of large retailers and large brands, but also small retailers and small brands go through the restructuring process. And there's a little bit of confusion in the questions coming through between secured and unsecured creditors' claims. What happens to an invoice that was sent before the filing of a bankruptcy? What the process is after the filing of a bankruptcy. So I know you touched on this earlier in the general portion of your presentation, but if you could go a little bit deeper, because we're getting quite a bit of inquiries around this.
Got it. Well, so an invoice that goes out before the bankruptcy filing is what is called a pre-petition claim. That invoice stands a very low probability once the filing is made of being paid. That is because it is on an unsecured status relative to two other tiers, so to speak, of creditors. The top tier are the secured creditors. Those are the banks. Those are the groups that, in the context of Neiman's, are owed hundreds of millions of dollars. They have secured that debt obligation with a perfected UCC filing against all of the assets of the debtor, in this case of Neiman's. The next class, so below that class, meaning that class gets paid back 100% before the next class gets paid, are the administrative claims. However, the administrative claims really kind of take on a different flavor because they need to be paid timely. Administrative claims are claims related to keeping the operation going. So think about your employees, the Neiman's employees, the Neiman's utility bill. Post-petition, the Neiman's accounts receivable that relates to brands. Those are all things that Neiman's needs to operate during the bankruptcy. So they're on an elevated level and they need to be paid timely, because if they're not paid, no one's going to show up to work. The lights are going to be shut off, and it's literally lights out and they're out of business, as opposed to what a Chapter 11 is supposed to be, which is you remain in business during the pendency of the bankruptcy. So to be clear, accounts receivable that the invoices that you send after the bankruptcy is filed are administrative claims, by and large, unless they are completely superfluous, but they won't be. And they are necessary for the bankrupt estate to operate, and therefore they are on a higher level. That still doesn't mean you should be sort of net 60 about them, because sometimes administrative claims don't all get paid because ultimately the business does fail. Sometimes they don't get paid because there is a sale process that's gone through which pays out all secured creditors, but at the time of the closing of the sale, there's still some administrative claims which don't get paid. And within the administrative claim class, there are tiers, and usually employees fall at the very top of that tier in terms of being paid back. So we still advocate on post-petition invoices that you send out, that if you can change the terms or if you can negotiate terms before shipping, that you do that so that you're paid very, very timely. I hope that helps provide some detail, Brian.
That was very thorough. Thank you. Similarly to the last question, you spoke about the business realities, the leverage side of a purchase order versus the legal realities, which is that it's a binding contract that one is expected to perform against. But we're receiving a few questions on that as well. So I thought this was a robust area that you could delve into a little bit deeper and add a little bit more clarity to that if you would like to take that question.
Yeah, I mean, suing to enforce contractual rights is, like I said, time-consuming and expensive. And in my experience, most brands don't have that kind of magic legal fees reimbursement language. So both retailers and this can also be on the flip side, right? Your production partners. If they're owed money and that amount of money is under, again, in my experience, $60,000 to $100,000, they may just stiff you on it because they know you're going to spend more in legal fees to get it than it costs. In other words, you'd be upside down on that. And you're taking the risk that, God forbid, you lose or they go bankrupt themselves and never pay you. So when I'm talking about leverage in the situation, what I'm talking about is trying to tee up those legal arguments because you're going to make them. You're going to threaten to sue. You're not going to blink. You're going to look like you're going to sue. But ultimately, what you want to do is scare them enough to pay you something, because getting paid 50 cents on the dollar today may be worth a lot more than maybe getting paid 100 cents on the dollar 2 years from now. But then when you subtract your legal fees, you ultimately got 42 cents on the dollar. So it's about looking like you're, really going to get in the ring and fight, but ultimately planning all of your arguments so that you create a massive disincentive for the party that owes you money to not pay you.
Thank you. Here's a big, vague one. I don't know if you've given this any thought, but I would love to hear if you have an answer for it. One specific question came in asking if you thought that Congress would bail out the fashion industry, however you would define that, manufacturers, brands, retailers, like they did with the airlines. So again, I don't know if you've given this much thought. It's a pretty specific question, but it's a big one. So
yeah. No, it's a great question. I know Tory Burch and a large group of industry players, including the CFDA, have been trying to sort of bring some collective action about. I even looked at a couple of letters, because anytime you talk collective action, there is some nervousness around antitrust, because there are antitrust regulations here in the U.S. that don't like businesses getting together to try to force collective action. Here, I think it's completely warranted. I think the issue with a bailout of the fashion industry is the definition of what the fashion industry is, unfortunately. As we know, the fashion industry is an amalgam of independent contractors, brands, raw material suppliers, production partners, and retailers. And not all of them are located in the United States. So it becomes very, very difficult for Congress to figure out who, in fact, they're bailing out, if they're bailing them out. And I think that will probably prevent any sort of actual institutionalized source of funds to be directed to the quote-unquote fashion industry, which I think is unfortunate, but I think is the reality.
Thank you very much. Have a few questions that came in regarding insurance. So to just summarize them, what are you seeing in the insurance arena? What sorts of risk and loss are you seeing that's being covered? What's not being covered? What can we expect from the insurance companies?
Right. Well, not surprisingly, they've sort of circled wagons, because the potential for liability here could be pretty massive, obviously. Business interruption insurance is kind of what people would be looking at right now, and the critical language there is whether the business interruption is caused by either a pandemic, sometimes it's specifically listed, or government mandated shutdown. And so a lot of policies do get triggered by the government mandated shutdown component. It's fairly compelling. Hey, we were shut down. We couldn't conduct business. The problem, or the counter argument that an insurance company might provide is, well, wait a minute, I'm looking at your sales. You were conducting business. You had online sales. Your warehouses were not shut down, because as you all probably know, warehouses and fulfillment and shipping are considered essential services, and they were not shut down. So that right now is kind of the insurance company stance, at least with respect to the clients that we've looked at it for. And obviously the client deals with the insurance company directly, but that's what we're hearing the insurance companies are saying. That may tee up, some lawsuits, but we shall see. And it is important to look at your policy if you do have business interruption insurance and see if it hits on one or the other of those triggers I mentioned.
Have some really interesting questions around employment law specific to furloughs, a few of those. So to summarize one question about furloughs, is there a time limit, maybe a matter of months, on how long a company can keep an employee furloughed, or is it different for each company?
It's different in each state, but usually it's a surprisingly long period of time. I can't recall New York off the top of my head, but it's I think more 180 days than 18 days. Furloughs can take long periods of time because sometimes furloughs are related to very, very different circumstances, like someone going on military leave or other situations that last hopefully a lot longer than this will last.
On the opposite side of the equation of employment law, there's a very specific question that came through from an employee who has said that his or her employer has made him or her take time off starting now, and that the employer told them that they will not pay them out for the days that they do not use. They were also told that they will not approve time off moving forward until mid-November. This person is scared, I guess, that he or she will lose many days that they have earned as the work year extends through the summer, of course. So they're just generally interested in knowing if the employer is allowed to do this and what sort of advice you would give to someone in this position.
Well, obviously not providing specific legal advice here, speaking more in generalities, but and recognizing that it's a state-by-state analysis. But it, in most states, is not permissible for an employer to mandate when you are taking vacation time or demand that you use it while you're being furloughed or effectively while you would have been furloughed. So I would encourage that person to seek counsel, and see what that counsel says about the prospects of them bringing a claim.
There are some general questions here that are not related to COVID that are interesting, and I think you can provide some really great commentary on. So we're going to move into a wider arena here. A few questions about, sorry, I'm just reading through these questions. Trademark, intellectual property, one specific to China, asking what the process is of having protection on intellectual property in China. So if you want to speak on intellectual property a little bit more generally or about acquiring a trademark in China specifically, there's quite a bit of activity and questions around this. So, Gotcha.
Well, maybe I didn't deep dive into the registration process here in the U.S. It should be noted that, as I said, in the U.S., to obtain a registration, you have to actually be using the mark in commerce. That means actively selling with the brand name on the product, whether that's a hang tag or sewn in, et cetera. Until you can show that, you can have an application, which is pending, but it will never molt into a full-blown registration. As I said, that's distinguished from the Chinese system, which is a first-to-file jurisdiction, where you can just come up with any name you want to, file, say, I intend to use this on clothes, and you will get a registration, even if you never use it on clothes. Oddly, Cuba is also a jurisdiction like that. There aren't many of them, believe it or not. But it's also important to note that the product categories covered by a trademark registration are limited. So while Class 25 is probably what most of the people listening sell in, which covers all apparel and footwear, essentially, accessories are a different category, and depending upon what the accessories are made of, can be multiple categories. They're typically Class 18. Eyewear is a different category. Cosmetics, perfume, all different categories. So back to like a Vera Wang, who sells in multiple categories. She has a trademark portfolio which has registrations in multiple product categories, and they all had to be obtained separately. So for larger brands, it can get pretty expensive to maintain these trademark portfolios, because think about it, you've maybe got 8 different product categories, and then you're not just going to register in the U.S. You're going to register maybe in 20 other countries. Boom, you're up to 160 registrations. So it can be both, administratively burdensome to maintain all of those because they come up for renewals periodically, as well as monitor them. But that's what big brands do, because the trademark is, let's face it, the crown jewel asset of your company. Your inventory comes and goes, right? Your inventory, you probably ruin your inventory right now. Inventory is worth a lot until it's not, and it's out of fashion. But ultimately, your brand name, which is the ability to sell inventory now and on into the future, is what accrues in value, and therefore protecting it, very, very important. So yeah, jurisdictions that are typical to obtain protection in are certainly, North America, portions of South America, most of Europe, and Europe does have a system where you can file, a complete EU filing. There's also a system called the Madrid Protocol, which has many countries that have signed on to it. So it's kind of a check the box type form that is filled out, but that doesn't mean you're not paying the fees in particular jurisdictions. So it can get expensive, but it's money well spent long term.
It's a really interesting question that is definitely general in nature, but I think it's applicable to what people are going through right now, in that there are a lot of people who are furloughed and laid off. The question is, can an employee who is a factory worker for you also work for you as an independent contractor? And again, trying to connect this to today, there's probably a lot of really great talent out there who is indeed seeking work, who may have worked in a factory, but has to, deal with being furloughed or laid off. And, where there's talent, obviously people who can afford it would like to bring them on as independent contractors. So one, generally speaking, is this allowed generally? And two, how do you see it playing out in this COVID climate?
And this, unfortunately, will have to be my last question, because I do have a 2:30 work call. But let me make sure I understand it, Brian. It's hiring from someone that works at a factory as an employee, hiring a brand wants to hire them as an independent contractor?
That's correct. Obviously, it's very fact specific, okay, whether they're competing or what, there's probably a lot that goes into it. Yeah.
In a lot of ways, it's just gonna be a determination of whether or not there's a non-compete on that employee. But during the furlough period, they should be free from that obligation. Again, fact specific, but as long as the brand is getting a representation, or ideally even seeing the contract, seeing the employment agreement from that potential contractor to confirm there's no non-compete, absolutely, people are free agents unless they've signed away their right to be a free agent, and can be both an employee somewhere as well as an independent contractor somewhere else. The things to avoid are obviously that contractor using the factory's resources to do the work for the brand. That would be a big no-no, right? Because they're not really paying for those resources. And or, like I said, an actual written non-compete.
Well, Doug, you finished with 5 minutes to spare for your business call that you have. I want to thank you for your participation. This was incredibly helpful. I want to thank our audience for dealing with some of the technical difficulties that we had, and for the very engaging and interesting questions that they provided. If anyone in the audience would like to connect with Doug, his information is up on the screen here. You could, of course, tune into his podcast, The Laws of Style. And as I mentioned, Doug, when you were off the phone, if you're still there, that your book is available for Father's Day, June 21st. Let's not forget Father's Day. So yes, Doug, thank you for joining us. This marks the conclusion of our webinar. Be on the lookout for future digital segments as part of our Right Now series. And don't forget to tune into the next Fashion Frameworks webinar on May 19th. You can check it out on our content site at fashionframeworks.com. So thank you to everyone again. It was a pleasure, and I look forward to seeing you again in one of these digital webinars.
Thanks, Brian. Thanks, everybody.